All rise. Judge Vanderbeek Court is now in session. Judge, this is case number JVB 1034, Thornton case.
Thank you.
You're welcome.
You all may be seated. Mr. Thornton,
Yes, ma'am.
you're back. How are you doing?
Oh, not as well as I'd like to.
Okay, all right. You brought this case before the court. What's going on?
Well, Your Honor, there's been some significant changes in my situation. And as you can see, Ms. Hernandez is not here today. And I have custody of the boy, and I have been, making our arrangement payments to her.
Okay.
But since the boy has come to stay with me, he's gotten himself into a lot of trouble.
Okay. What kind of trouble?
Well, he's been burglarizing some residents, and he was in an accident due to a police chase.
This is AJ, right?
Yes.
Okay.
All right, folks, let's dive into this intense courtroom drama. The judge calls the session to order as Mr. Thornton steps forward to present his case. He explains that he has full custody of his son, AJ, and has been making arrangement payments to Ms. Hernandez. However, things have taken a turn for the worse. Jay has been involved in serious trouble, including burglary and a police chase that ended in an accident. The judge listens carefully, asking about any changes in living arrangements or financial burdens. Mr. Thornton, clearly frustrated, details the growing financial strain caused by Jay's reckless behavior. But this case isn't just about money, it's about responsibility, legal obligations, and the challenges of raising a troubled teen. The courtroom waits anxiously to see how the judge will handle this complex.
And Ms. Hernandez refuses to acknowledge her responsibility to help me in covering some of these costs. I mean, the medical costs are quite extreme. My insurance is refusing to pay because it was a criminal act. In fact, they're probably going to drop me.
Okay.
And
If I remember correctly, you guys agreed to no child support during mediation.
yes, ma'am, we did.
Okay. And since that time, nothing has really changed with the living arrangement. AJ still lives with you,
Yes, ma'am.
and you still have not been paying child support. You've been making the back child support payments.
Yes, ma'am.
Okay. Other than AJ getting in trouble, what else has happened? Like, what has changed?
Well, she has moved out of state, quit her job, so her insurance no longer covers him, that aspect. And, the court costs, fines, and due to that accident, there was a lot of damage in which he's liable for, or I am, and it's almost impossible.
Okay.
For me to,
But AJ was double insured by both of you, right?
yes.
Okay, here's the issue. In order to modify any type of child support situation, whether you receive child support or you don't receive child support, there has to be what's called a material and substantial change. That means that AJ's living arrangements would have had to have changed. Something about his educational expenses have changed. Something about mom's income would have had to have changed. But in you guys' case, you agreed in mediation to no child support. So to go from no child support to receiving child support, you would have to fall in one of those categories for a material and substantial change. And based on what you said, you really don't fall into one of those.
That's very disappointing. So she's just.
Thornton explains his predicament, detailing how Ms. Hernandez moved out of state, quit her job, and no longer provides insurance for AJ. Now, he alone covers medical bills, court fines, and accident damages. The judge reminds him that they previously agreed to no child support and questions if a substantial change has occurred. Thornton struggles to prove this since AJ has always lived with him. As frustration mounts, he realizes the legal barriers ahead. This moment highlights the intense emotional and financial stakes. as Thornton's plea for support collides with the judge's firm stance on legal requirements.
Free of any obligation? I mean,
Well, I wouldn't say she's necessarily free, but remember, you all did come to an agreement in mediation to no child support. So in order to start receiving child support, you would have to show that something has changed. So let's say, for instance, at the time of mediation, AJ still resided with her. Now he lives with you, then we can entertain child support at that point. But nothing has really changed since you guys have gone to mediation. Therefore, you wouldn't be entitled to receive any child support, unfortunately.
I understand. I mean, is there nothing I can do? Absolutely.
As far as I'm concerned, no, there's nothing you can do. Yeah.
All right. Thank you.
Okay,
Your
is there
Honor.
anything further?
No, ma'am. Not at this time.
Okay.
That's about it.
Okay, well, if there's nothing further, you're dismissed.
Thank you.
Judge takes control, explaining that child support modifications require a material and substantial change, such as shifts in living arrangements, educational needs, or income. She notes that none of these have changed since the mediation agreement. Mr. Thornton, frustrated, argues that Ms. Hernandez has no obligations. But the judge firmly clarifies that their agreement was mutual and cannot be altered without legal grounds. Her direct no-nonsense approach leaves no room for debate, and Thornton is left disappointed. This moment captures the core tension: sharp legal reasoning versus an emotional plea, creating a dramatic and compelling courtroom exchange. Clips. Judge firmly reiterates her ruling. Mr. Thornton is not entitled to child support under the current circumstances. She emphasizes that the mediation agreement remains legally binding and, without a material and substantial change, it cannot be modified. With that, she dismisses the case. Mr. Thornton, though polite, leaves the courtroom visibly frustrated, realizing that the financial burden will continue to rest entirely on his shoulders. The judge's final remarks reinforce the importance of legal agreements and the difficulty of altering them without significant justification. This moment serves as a resolution to the case, while also delivering a crucial takeaway: child support modifications require more than just financial hardship. They demand legally recognized changes. Shifting to a legal breakdown, an expert explains that Texas law requires a material and substantial change, such as a change in income, living arrangements, or the child's needs, to justify a modification. Since Mr. Thornton failed to meet these criteria, the original mediation agreement remained in effect. The video closes with a call to action, encouraging viewers to share their experiences and subscribe for more legal insights, reinforcing the complexities of child support laws.